All right, welcome everyone again to the University of New Mexico Law and Mental Health Didactic Series hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. Thank you everybody for joining us here today. I'm Anthony Perillo, the Forensic Psychology Training Director in the Department of Psychiatry and Behavioral Sciences here at the University of New Mexico. Before we get started today, a couple of things. Just make sure if you have questions today, ask them in the Q&A box anytime you feel comfortable, not the chat box, the Q&A box. Know that we hold off to the questions until the end. We try to get to as many as possible. It's not always possible for us to get through all of them, so just forgive us if we can't get to yours. If you are pursuing continuing medical education credits, there will be a sign-in sheet that will be posted in the chat fairly shortly. If you're pursuing APA continuing education credits, there will be a link that's posted again in the chat box around the last 5 or 10 minutes or so of the talk. Make sure you open those links before you exit the webinar today, and make sure you save your certificates of completion because we don't have copies of those for you after the fact. There will be a recording link and slides that should be available sometime later in the week for you. And as a heads up for next week's talk, next week we have Dr. Skye Stevens, who will be discussing treatment of people with petahemophilic interests. But that's for next week. This week, now it's the time for everything that we've been waiting for. I'd like to introduce you to today's speaker, who will be discussing issues of competency and validity for youth pleading guilty. This is Dr. Tina Zottoli. Dr. Tina Zottoli is an associate professor of psychology at Montclair State University and a licensed psychologist in New York. Her scholarship centers on decision-making in legal contexts with a focus on outcomes for adolescent defendants. She has a particular expertise in guilty plea decision-making of both youth and adults and has consulted on several cases involving suspected or proven faults in admissions. Her work on recidivism risk in persons released from life sentences for crimes committed as youth has garnered national attention, and she's testified before the legislatures of several states with respect to proposed second chance legislation for youth. Dr. Zottoli's scholarship has been funded by a number of organizations, including the Vital Projects Fund Incorporated, the American Psychology Law Society, and the American Bar Endowment. Her clinical practice focuses on issues pertaining to legal competencies, violence risk, and sentence mitigation, and she frequently consults on cases involving youth and young adults. When not working, she can be found rock climbing, kayaking, and cross-country skiing. Not all at the same time, but then again, knowing her fortitude, I wouldn't be shocked if she figured out a way to achieve all of that at once. Dr. Zottoli, Tina, on behalf of the University of New Mexico, can I say we are excited and honored to have you joining our series and thankful for you sharing your expertise with all of us today. I'll go ahead and throw it over to you.
Well, thank you so much, Anthony. It's really great to be here. It's so important to be able to give back, and especially when I've had the opportunity to have a look at some of these talks that have been given through this series. It's nice to have been invited and to be part of this. Well, I guess I'm going to skip over a few of these introductory slides since Anthony already introduced me. And I guess all of this information is already available to everyone. And we'll jump right into the talk. As the title of my talk implies, we're going to be talking about youth who plead guilty to crimes and whether or not these youth have the requisite legal abilities to make these decisions. These are the learning objectives that I laid out for this seminar. By the end of the seminar, I hope that you'll be able to really describe the legal context that youth find themselves in when they're making these plea decisions, to get a sense for how developmental immaturities and cognitive abilities and psychosocial function can affect the plea decisions of youth, and ultimately be able to evaluate or begin thinking about whether or not the established procedural safeguards that we have in place for protecting the rights of youth and ensuring that they go through this process adequately informed, whether or not these are adequate. To do this, I actually have to give some brief background on both the plea process and on adolescent decision-making, adolescent development and decision-making. I could obviously spend a full hour on each of these topics. We can't do that, obviously. So I really just want to provide enough background here so that when I talk about the research on the capacities of youth in the guilty plea context, it'll be readily understood. So I'll be leaving out a lot of details, which, by the way, is really hard for me because I like to talk about this stuff, but To compensate for the fact that I'll be leaving out a lot of information, I've included plenty of references that folks can seek out if they want more detail and more information. Anyway, after I go through that, I will cover the research on youth legal abilities in the plea context, hopefully highlighting along the way some of the disconnect between what youth are expected to know and do and what youth can actually know and do. And then I'll wrap up with a few thoughts on implications for research policy and so forth. Before jumping into the content of my talk, I do just want to take a minute to acknowledge that all the things that we're going to be talking about today with respect to potentially the disadvantages that youth may be at in the system that isn't necessarily sensitive to their developmental needs. I just want to remind us all that these problems are disproportionately affecting youth from minority, racial, and ethnic groups and economically disadvantaged backgrounds. The disparities that we see in the system today, they reflect the racialized policies and the racialized history of the justice system in the United States, and the mechanisms by which systems really perpetrate racial disparity, even when we've come to identify that the problems exist. So I just think that's an important place to start, to remember that this is disproportionately affecting Black and Brown youth. All right, so I guess we'll jump right into the crash course on the legal landscape of adolescence in the guilty plea context. I guess the first place to start is asking the question, why should we even be talking about this? And the short answer is because most convictions in the United States, and this is true both in the criminal courts and the juvenile courts, are by guilty plea. Despite what you see on Law and Order, the criminal trial and even the juvenile adjudicative hearing are really relics of the past. It wasn't always like this. For most of our history, courts and legislatures really were not inclined toward plea bargaining. If you're interested in that history, and it is an interesting history, I've provided some references here that you can dig into. But for our purposes today, I think it's just important to recognize that the system wasn't designed to be a system of pleas. It was designed to be a system of trials. We were meant to be, individuals who are convicted of crimes were meant to be convicted by a jury of their peers. They weren't meant to convict themselves, right? But our system rapidly became a system of pleas. And so it's important for us just to recognize that many of the protections then that were built into our system, they don't necessarily take into account the differences between the plea process and the trial process. So trials are public. Defendants who go to trial are protected by, a host of procedural and constitutional rights. And guilty plea negotiations, they occur behind closed doors. Many of the rights that are afforded to defendants at trial don't attach to defendants who plead guilty, and so forth. So the next thing we should do is just take a really quick look at some of the differences between pleas and trials, some of the rights that defendants are asked to give up when they plead guilty. Some of these should be pretty obvious, right? If you're pleading guilty to a crime, you're obviously waiving your right to the protection against self-incrimination. You're waiving your right to have the state prove your guilt beyond a reasonable doubt and to confront witnesses. But others of these might not be as obvious. So for instance, exculpatory evidence, we'll talk about that one. By the way, what I mean by exculpatory evidence is evidence that is suggestive of innocence or that would lean in favor of acquittal. So defendants who go to trial have a constitutional right to exculpatory evidence. And if a prosecutor has exculpatory evidence and doesn't turn it over, there are, at least theoretically, legal remedies that are available to those defendants. But this right has never been expressly extended to defendants who plead guilty, and states vary considerably with respect to how they legislate or how their courts and determine or what evidence defendants have access to, including exculpatory evidence. But I'll point out here, just even when states do make access to exculpatory evidence explicit in the context of the plea, In reality, most plea offers are made and decided on far too quickly for either side to really fully investigate the case. So as we'll see in later slides, many defendants are left in the dark on the evidence in their cases. In any event, the purpose of this slide, as I said, we're trying to move quickly here. The purpose of this slide isn't so much to go into each of these in any kind of detail, but it's really just to point out that when a person pleads guilty, there are a number of important protections that they are giving up. And so the expectation, of course, is that the individual doesn't just know, yes, I'm waiving these rights, but that he understands the function of those rights, right, with respect to the protections they provide and how they might facilitate his own defense, and that he's waiving those with that full knowledge. I think we could agree that these are relatively complex ideas for young people, and they're complex ideas for adults too. So let's turn now to take a look at the legal standards that are in place, or the legal protections that are in place to ensure that folks go through the process with adequate understanding and appreciation. So for a guilty plea to be valid, a defendant must have the capacity, as I've just discussed, right, the capacity to understand and appreciate those rights in order to exercise them or waive them. But also at the time that the plea is entered, he must actually have adequate knowledge of the rights he is waiving. And his decision to waive those rights at that time must be voluntary. So there's the capacity, which is the prerequisite, of course, and then there is at the time of the plea, is that defendant adequately informed, and is the plea voluntary? So there's two legal requisites that are implicated here, right? So adjudicative competency that I'm sure most people in the audience are well acquainted with. I know there have been a few of these sessions on issues related to adjudicative competency in the past couple of months. But then there's also the knowing and voluntary standard for a guilty plea. And we're just going to take a really quick look at these things. And I've got my eye on my timer here to make sure I don't go too long on these background topics. So very quickly with competency, as most people, of course, will be familiar, the Dusky standard, the Dusky v. US set the standard for competency in the United States, and every state has a similar language in their laws, but the defendant must have sufficient presentability to consult with their attorney with reasonable degree of rational understanding and a rational as well as factual understanding of the proceedings against him. The way that competency has been operationalized in the legal literature and in forensic assessment, this factual and rational understanding implies not just that the defendant has a basic understanding of legal facts, but also appreciates, right, how the legal process and potential outcomes affect him or her personally. And additionally, they have the capacity to reason about those processes and outcomes in ways that can contribute to their defense. Again, most people will be familiar. Competency is usually predicated on some discernible mental disorder, but it's well established that developmental immaturity can adversely impact the adjudicative competency of youth who are processed in the criminal courts, with the research suggesting that youth younger than 16 or with other issues like low IQ and so forth, presenting with the most pronounced deficits. Problematically, courts don't always consider or recognize developmental immaturity absent some other diagnosis. This is true, by the way, not just in the criminal courts, but also in the juvenile courts, where there's really remains a lack of consensus as to whether there should be, or if there is, what is it, the standard of competency in the juvenile courts. As of 2020, a survey done by Panza and colleagues, 15 states statutorily identified developmental immaturity as grounds for juvenile adjudicatory incompetence. In any event, for our purposes here, whether developmental immaturity is or is not adequately considered or is recognized as sufficient on its own, surveys with attorneys suggest that issues of adjudicative competency are not frequently raised in the context of plea decisions. And this is actually true even in cases where attorneys may have concerns. And there are a host of reasons for that we don't necessarily have time to get into here, but I just think it's important to keep that in mind, that many youth are likely, in fact, going through the process without the capacity to truly appreciate the decisions or the outcomes for their own cases. So in terms of the knowing and willing inquiry, as per Boykin v. Alabama, before a defendant can enter a guilty plea, the court has to be assured that the plea is voluntary and is made with the full understanding of the consequences. Most jurisdictions are also going to require a sufficient factual basis for the charges. Now, there's a lot of jurisdiction to jurisdiction variation in how this is, done by the courts, but generally speaking, the validity of a guilty plea is typically determined by oral plea colloquy. Plea colloquy, by the way, is just a routinized, formalized set of questions. Generally, simple verbal or written affirmations are sufficient to satisfy the court. But as I'm going to just briefly show you here a little bit of research, the data suggests that these safeguards are maybe inefficient. Plea colloquies are quick. So a recently published paper by Redlick and colleagues looking at plea colloquies in a Virginia jurisdiction found like the length of the juvenile hearings about 7 minutes on average, and the criminal hearings about 13 minutes on average. When you think about that, I mean, 13 minutes, we're mental health professionals, right? 13 minutes is not enough time to adjudicate whether or not an individual has an understanding of the potentially life-altering decision he's going to make, let alone time to really assess if he has the capacity to understand. So the implication, of course, then is that the answers to these questions are being vetted or should be vetted before that defendant gets to court, right? Before that defendant is standing in front of the judge. But again, here you can just see a couple of data points that I pulled out. Research and numerous anecdotal reports suggest that's unlikely the case. Timeframes for plea decisions could be very quick. In fact, sometimes there could be really aggressive expiration dates that are attached to the plea offers. So these are things called exploding offers. Access to evidence could be limited. So, for instance, about half of individuals that were interviewed by Redlick and Summer in 2012 who had pleaded guilty, their guilty pleas were vetted, deemed valid by the courts, said that they never saw the case evidence, the evidence against them. Additionally, the differential between the plea sentence and the sentence that you might get at trial if convicted can be so large that many defendants feel they have no practical choice. Nevertheless, this is the legal inquiry that's made, and this is typically how it proceeds via the oral colloquy or written tender of plea forms in the courts. So that was quite the crash course. I think I might have managed to do that in less than 12 minutes. To summarize the legal landscape here, most defendants plead guilty. Many of the protections that are offered to those who go to trial haven't been extended to those in the plea context. Competency is not frequently addressed, and the plea colloquy is typically pro forma. So kind of already have some bad news, and we haven't even gotten very far yet. Anyway, if you think that was a crash course, buckle up, because I'm going to go even faster through the adolescent decision-making material, because I trust that this audience, most people are probably already familiar with most of this, and I just really want to highlight the high points. We all recognize adolescence is a transitional stage, right, between childhood and adulthood, and there are a number of changes in cognitive capacities and socio-emotional functioning that are going to facilitate that transition into adulthood. For an excellent, I think, comprehensive review on adolescent development and decision-making, I would highly recommend Eisenogel and Kaufman's 2021 paper. I have all the references in the back of the slides, but for our purposes, I think really the key points that I want to raise here is just that development across the various domains of function are asynchronous and uneven in this developmental period, context dependent, right? So the ability to proficiently use or engage certain capacities or abilities are going to be dependent upon the context, as we'll talk about in a minute. And of course, individual differences are going to be apparent. There could be wide variability actually within age as well, due to variations in timing and the pace of maturation across domains. So I just want to briefly look at cognitive function, psychosocial function at a very high level before we get into the data on kids in the plea context. Fairly well established that basic cognitive functions reach adult maturity by about age 16. So these are the things we're talking about here: memory, attention, thinking, calculating, problem solving, hypothesis testing. In contrast, the executive functions develop across adolescence, and you'll see changes, gradual changes in abilities into young adulthood. And these tend to be context dependent. So first of all, what do I mean by executive functions? So these are the skills that, this is an umbrella term, right, for the set of kind of complex higher order functions that enable us to employ our cognitive abilities in the service of goals. So as I have listed here, some examples: planning, sustaining focus despite distraction, thinking flexibly, so forth, inhibiting prepotent responses. Complex decision-making obviously relies on the ability to engage various executive functions, and we do see gradual changes over the course of adolescence, as I said. But generally speaking, right, for the most part, by virtue of their mature cognitive abilities, adolescents are capable of engaging in deliberate and well-reasoned decision-making. The problem is the capacity breaks down rapidly in situations that are emotionally arousing or time-pressured. These are the so-called hot contexts. I guess, arguably, we could say that there's few contexts that are more fraught with emotion or time pressured than criminal adjudication. So again, you see where this is going. But in any event, decision-making tends to break down in those contexts, as opposed to contexts which permit more of a calm deliberation, or contexts in which like the outcomes aren't as emotionally salient, so-called cold contexts. Obviously, adult decision-making also degrades under stress. It's also suboptimal, but the effects are just far more pronounced in youth, because adolescents have a considerably more difficulty down-regulating their emotional responses than adults do. And decision-making, therefore, in these contexts breaks down. So to just give a concrete example, it's why, you know, for example, even though a youth may be quite capable of identifying a risk, they may often still make decisions that appear insensitive to those risks, or that appear myopic for future consequences. Self-regulatory abilities, or psychosocial functioning, develop gradually across adolescence, and the development across these domains can follow different trajectories. So we're going to see changes in a number of these self-regulatory capacities or psychosocial functions: sensation seeking, future orientation, susceptibility to peer influence, and so forth. Sensation seeking and reward sensitivity tend to peak during adolescence and then begin to kind of abate as you go into later adolescence, into adulthood. Whereas you'll see more linear and gradual changes in things like future orientation and impulse control maturing into early adulthood. Other things we might mention here, again, just keeping things at quite a high level. Adolescents are particularly sensitive to environmental cues, especially socially relevant cues, and motivational cues that signal potential rewards can diminish their capacity to engage in self-regulation, leading them to make suboptimal decisions or risky choices. I'm checking my time again, make sure I'm not going too long here, but I'll just briefly discuss that there are, of course, neural correlates to all of these changes. There are a few neurocognitive models that have been proposed to explain differences in the decision-making of adolescents and adults. It's not important for us to get into the details of these models, but generally they all recognize and agree on three main sets of findings that seem to underlie these primary differences that we see between adolescents and adults. And these things are that there is a protracted or a prolonged development of cortical structures and systems that are involved in cognitive control processes or mediate cognitive control. relative to a far earlier maturation of subcortical structures that mediate approach and avoidance or motivational processing. Additionally, there's this increasing strength and efficiency of functional connectivity throughout development into early adulthood. And so these changes essentially help explain why it is more difficult for adolescents to engage in deliberative or optimal decision-making in these emotionally fraught or time-pressured contexts. Like, I recognize here, even as I'm saying this, that I'm oversimplifying considerably. I trust that if you want more information, you'll seek out the references that I put here, or of course, ask questions at the end of the talk. I'm happy to talk more about it. I do want to just mention briefly, before I come to the end of this section, another important perspective for understanding adolescent decision-making. This comes from fuzzy trace theory, which is a dual process model of memory and decision-making that was proposed originally by Valerie Reina and Charles Brainerd. I don't have a slide on this, but in a nutshell, we tend to encode information that's relevant to decisions in two forms. We tend to encode information as verbatim form or precise form, for example, numerical information. We also tend to encode information in terms of its gist or its meaning or value-based, or rather as meaning or value-based representations. And these representations are based on our accumulated knowledge and experiences. So the insight from fuzzy trace theory is that most adults rely on gist-based representations when making decisions, which allow us, for example, to make optimal decisions quickly or in like a pressured context. In contrast, adolescents tend to rely more on precise details or that verbatim representation, which can lead to suboptimal decision-making in certain contexts. Again, I don't have time to get into this in any kind of detail, but I did want to just throw it out there and mention it because this model is becoming increasingly important to the study of guilty plea decision-making, both for youth and for adults. So I did want to at least mention it. All right, so it's important for me to just note that everything I've talked about, all of this research, the studies that I've discussed are really focusing on normative development. I would be remiss if I didn't acknowledge that factors that exacerbate developmental differences or that prolong development, excuse me for stumbling over my words here, factors that exacerbate these developmental differences or that prolong development of these functions are overrepresented among youth in the system. So here's just a sampling of some of the things that are represented much more highly among populations of justice system involved youth than in the general population. So for instance, things like adverse socialization histories or prior incarcerations could prolong maturation of some psychosocial functioning, neurodevelopmental diagnoses, trauma histories, and other adverse childhood events. So it's important to keep that in mind, that kids in the system will likely have more difficulty than typically developing adolescents might. So to sum up the crash course on adolescent development, adolescence is a developmental period of substantial social, cognitive, and neurobiological change. Yes, adolescents have a mature capacity for analytical reasoning, but their judgments and decisions can often reflect an insensitivity to future consequences and a failure to attend to risk. And this is in part due to the fact that they have more difficulty countering dysregulating influences, making them particularly vulnerable to poor decision-making in emotionally heightened or time-pressured contexts. And finally, many problems that negatively affect or prolong development, mature decision-making, are overrepresented in system-involved youth. I managed to do it. I wanted to get through that in just about 20 minutes, and I think I did 22. So I can slow down a bit and spend the rest of the time talking about the research on youth in the system, and then hopefully leaving plenty of time for questions, which are probably the most important part of the talk. So what do we know? Well, The first thing that I want to say is that a real focused interest, a focused program of research on guilty plea process, guilty plea decision-making generally, is really still relatively young in the among psycholegal scholars. I would say that psychologists in particular have been studying it in earnest for the last 15 or so years, and the research has just burgeoned. But and so on the one hand, we actually have quite a number of studies that have focused on youth in the system, considering how relatively young the research actually is, right? 15 years is really not that long when you think about trying to understand something as complicated as guilty plea decision making. Having said that, though, on the other hand, even though we have a lot of studies that look at kids, the system is really complex, right? There are 50 states, District of Columbia, federal government, various protectorates, various jurisdictions within states and so forth, each having their own set of policies and procedures and laws and so forth by which their justice systems follow. So it's not always easy to generalize, right? The research from one study to another. That said, I think the research is in a place where we can make some clear, we can glean some clear insights. And so what I wanted to do today is just to present some of the things that we know right now about adolescents' understanding of the plea process and how they make decisions in that process. And I'll highlight some specific data from studies that have actually focused on youth in the system, just to give some more concrete examples of what this looks like. So to start off, I want to contextualize the process or the situation that kids are in. So the differential between the plea and the potential trial sentence that youth are often being asked to decide between can be quite large. I mentioned this earlier, but I want to give you a little bit of data here. And by the way, there's more data than what I'm showing you, but I'm pulling some concrete data points from my 2016 paper here, just to show you how large these differentials can actually be. By the way, this is true for adults too. This is not just specific to kids, but obviously the focus of today is how this affects kids. If you take a look at these data here, I apologize, lost my train of thought there. The percentage of youth that were facing plea charges, their original charges were carrying sentences between 1 and 10 years. You had about 77% of the sample were facing charges that range somewhere between 1 and 10 years if they went to trial and were convicted. But their plea sentences, 93% of those youth were sentenced to sentences that were less than 1 year. And since I know these data, they're my data, I can say actually that the vast majority of those youth weren't sentenced to any time at all. They were sentenced to probation, which is something quite unique to New York, which maybe if we have time, we'll talk about later. The reason I was thrown off earlier, by the way, when I looked at this, was that column shouldn't say arraignment. It really should say original charges. This was self-report data, and I'm not quite sure exactly when what charges the youth were reporting. In any event, that's a minor detail. As you can see here, the differential between what youth believed they could get if they went to trial and what they would get if they pleaded guilty is quite large. And these types of data are replicated across archival studies, other field studies, and so forth. Secondly, the time to make decisions can be quite short. I have plenty of great anecdotal stories that I could share, but here again, just to show some data from our 2016 study, about half of our youth reported having less than an hour to make their plea decision. Now, I want to just clarify something here. These data don't differentiate between time pressures put on them by the prosecutor or other factors that were contributing to the time pressure. So for instance, many of the youth found out about their plea at a court appearance. And if they didn't take that plea, then it might have meant going back either to detention or home, waiting for time to pass for another hearing. So they felt pressured in order to avoid that prolonged process to take the plea. Others were experienced pressure from prosecutors and so forth. But nevertheless, this is a very short amount of time to make a considerably life-impacting decision. And about 35% of the youth said that they had more than one day. And then finally, again, just to contextualize this, take a look at the actual attorney contact. So the modal number of meetings that our youth reported having with their attorneys was 2 or 3. That's not a lot, particularly considering that these meetings with attorneys were often in conjunction with some other scheduled event, like a court hearing. By the way, I want to make clear that this is not in any way an attempt to criticize the attorneys. Public defenders the caseloads of public defenders are huge. I think we all know that, we're all aware. In fact, in New York City, we have a fairly well-funded public defense system compared to other parts of the country. Are quite good, and still here the caseloads are enormous. So again, this is more pointing out a problem with the system, certainly not an issue with attorneys. But I want you to think about this in light of what we just talked about with adolescents making decisions in pressured contexts, under time constraint, without having enough scaffolding from maybe their attorneys or other adults who can help them make a deliberative decision. So moving on to the data on what we know about adolescents' understanding and appreciation. Now I have appreciation here in parentheses because most of the research to date really has been getting more at the general legal understanding. It's a little bit harder to get at the appreciation, although some of the data does point to the extent to which they really understand the implications for their own personal lives. So what are some things that we can pull out of this literature that we know is likely to be the case? Well, we see time and time again that there's just generally poor understanding of the vocabulary that's used in plea colloquies or on tender of plea forms. Studies just show consistently deficient comprehension of the plea process. And I'm going to pull some data out here in a minute to give you some concrete examples. I think, though, a really important point that I want to make here is that youth don't necessarily know that they don't know something. And that can be quite problematic when verbal affirmation is used as an indicator of understanding. So let's take a look at just a couple of studies here. One of the earliest studies that looked at what kids understand about the plea process, Cabin and Quinlan, I hope I pronounced those names correctly, studied 98 youth that were actually in the process of juvenile justice proceedings. So these were kids that were in the process, in the process of they were going to be entering pleas. 29 of those youth actually received direct training. And they tested these youth on 36 words and phrases that were used on the tender of plea forms, again, in their jurisdiction, in that juvenile court. So what's, I think, interesting about this study is that on average, the uninstructed group and the instructed group, there's a difference, of course. The uninstructed group on average defined about 10 terms, and the instructed group some more, right? I think, was that about 55% more? Or, no, not that. You could do the math. Definitely recognized and defined a few more words. But when you look at the actual accurate definitions, what you see is that although the instructed group did identify more words and give definitions, they didn't necessarily have an equal % increase in the number of those terms that they accurately defined. And I think that's an interesting point. it might be a little bit clearer when you look at some of the, so essentially they might recognize a term now having been instructed on it, but not necessarily understand it in a way that they could actually explain it back to you or understand how it applied to them. In my 2019 study with Dr. Dafri Kapoor, we interviewed 69 youth and 60 adults that were, again, convicted by plea in criminal court. So these are folks, right, that in our case, that have gone through the process. So these are all folks that were convicted by plea. What we found interesting, 85% of the youth who knew they can go to trial, okay, and 98% of adults knew that they could have gone to trial. But what was more interesting was that when we asked them what that meant, only about 67% of those youth had even a rudimentary understanding of what the trial process was, whereas almost all of those adults did. Just to give you a sense of what their understanding looked like, well, here's what you got. Well, what happens at trial? After the youth said, I know I could have gone to trial, what happens at trial? Well, I'm a little fuzzy on that one. What happens at trial? You get a sentence, you go to the judge, and the judge decides what he wants to do. Well, that's not accurate, you know. And so when you think about that, right now, this kid is deciding between a definite plea sentence, and he thinks he just goes and stands before the judge, and the judge decides what to do, right? So it's kind of an interesting problem, isn't it? When they think they know what a trial is, but then really in reality, they don't. So Fountain and Woolard, 2018 paper, they interviewed 18 juvenile defense attorneys about how they communicate with their clients about things. And the reason I wanted to talk about this study here is that some of the common themes that came out of their papers, there's not enough time to explain information and to assess competency. And so oftentimes you're relying on affirmative responses or the kid sort of repeating back to you what they've said. And again, just to reiterate here, the attorney is also saying, you know, plea decisions are needed quickly. There's really not enough time to really think about it in advance or even to negotiate offers. Okay, so moving now to what we know about how kids are making decisions in the in the plea context. There are a few things that we know. I do want to point out, like the decision-making research is a little bit complicated. Methodologies are very different. The populations that people are studying can be very different. We'll talk more about those limitations later if there's time. But I think there are a few important things that we can pull out. And one is that youth tend to consider fewer options generally, right, that they have available to them. And they may disproportionately focus on the short-term and immediate outcomes that are available to them, or identify more short-term and immediate outcomes. I just want to be careful here, though, not to overstate this. The adolescents in our study, and in other studies that have touched on what youth were thinking about when making their actual plea decisions, youth are very capable of identifying some of the long-term consequences of the plea decision, both the benefits and the adverse consequences of plea decisions. What we really need to get better at in the research, or I should say get better, I wouldn't really to do in the research, really hasn't been done so well yet, is to really start to understand, though, when it comes to the decision calculus, how are they weighting these things, right? What is taking more weight? And we do have some information on that, which I'll talk about in a minute, when we ask kids what was their primary reason for making their plea decision, and we'll look at that in a second. But one big takeaway is that youth do tend to consider fewer options, and they do have a disproportionate focus on short-term and immediate outcomes. With increasing age, there's some research to suggest that relevant legal factors become a little bit more salient or a little bit more predictive of plea decisions. So that's another thing that we see, which kind of makes sense, right? Recognizing more or less what's actually happening and what could affect the outcome at trial and so forth. So there's some research to suggest that you do see those changes from late childhood into late adolescence. What are some of the, so when you ask kids, why did you make your plea decision? ultimately, what kind of information are we getting? There's a couple of different ways that we've looked at this. A couple of different studies have looked at it, I should say, in different ways. People have looked at it experimentally, right? So manipulating conditions, having people go through the plea process in a laboratory and rendering their, the reasons for their decisions. And then a handful of studies have actually asked either attorneys or youth and adults, comparing them on their decisions. And so just to quickly go over some of this, juvenile defense attorneys, again, from the Fountain and Woolard study, generally, for the most part, avoid incarceration and go home. And you're going to see that pretty common across studies. Makes sense, right? Avoid longer incarceration, get a less sentence. That's true for adults, it's true for kids. Other things include just avoiding having to see the witnesses against me or have to confront those witnesses in court. In juvenile court, pleading guilty to avoid adult prosecution, or pleading guilty to avoid the trial process or other adverse procedural adverse processes. In a sample of 193 incarcerated youth in California, these are youth that were convicted and incarcerated on serious charges. Malloy and colleagues asked not about the specific charges that they were, not necessarily about the specific charges they were convicted of, but just generally speaking, have they ever, this or otherwise, entered a true or a false guilty plea? And these were, and for those that had, they were asked why, right? What were the reasons? And so this just helps us have a look at some of the differences. So we're going to talk about false guilty pleas in a minute. Some of the differences in the reasons that these youth were giving for having entered either a true or a false guilty plea. And obviously some of the differences here might seem maybe quite obvious, right? So false guilty pleas to protect another person. Obviously evidence strength, much more likely to be the case in the true guilty pleas than the false. However, you'll still note that this instrumental reason, getting less time is the most important or most common reason. This kind of stuff has also been seen in the laboratory studies that I just mentioned. I know I'm going a little bit long here. I wanted to kind of keep this to under 45 minutes. I'll try to move through this a little bit more quickly. But to date, I think this is correct. And if I'm not, I apologize for having missed this study. But to date, I think that this paper, my paper with Tarka Dafri Kapoor in 2019, is the only paper that has actually directly compared the plea decisions of youth and adults who had actually in the system, who had actually been convicted of crimes, and interviewed them about those plea decisions. And so these data are useful, but it's, again, just one jurisdiction, and there are so many caveats, right, that attach to that. But these are the reasons that youth were giving for their plea decisions in comparison to the adults. And here you do start to see some developmental differences emerge, but again, reduction in charges being the most common. I think some of the things, however, that came out of this study that were more interesting to me was actually this sense that youth were, I'm sorry, let me back up a little bit. As you look here, you can see things like family concerns were obviously a little bit more rated as the most important reason for adults than kids. And some of this stuff it may be obvious, right? Because adults have more responsibilities and family obligations and so forth. But I think what's interesting that comes out of these data is that more youth than the adults were saying things like, well, because I was told to do it. My parents wanted me to do it. My attorney wanted me to do it, or because I was actually guilty. And also, as you see, to end the process, right? I didn't want to have to keep going back to court. Some of the kids would say to us, it was just too much to keep going back to court. But what I thought was really interesting in this study, and I wish I had more time because we did get a lot of cool data in this study, and not all of it's even been published yet. We asked the individuals to tell us what they thought about, what they were thinking about their likelihood to be convicted at trial, right? For those who knew that they could go to trial. And what I thought was interesting were the reasons that they gave for those estimates. So why did they have that expectation for trial outcome? And I thought that what was telling about these data were the transparency of guilt or innocence that's really more pronounced in the youth. Additionally, adults, not such a huge difference, but double the number at least, were more inclined to think about factors like, well, my lawyer wasn't good at his job or so forth, where kids generally trusted their lawyers, generally thought their lawyers were doing a good job. So there are these kind of differences there in the way that kids and adults are even perceiving their, at least again, in these data, and I keep caveating that because it's one jurisdiction, right? Okay, so I think this is my last slide. I hope I'm not going too long here. I want to talk a little bit, it's not my last slide, but my last slide on the research. I want to just talk a little bit about voluntariness and autonomy. All I'm really going to say here is this is a really sticky concept. It's difficult from both a legal perspective and from a psychological perspective. So what I really want to do is just say we have kind of limited data to get at this, but I think there's one way to kind of think about whether or not the plea system is coercive generally, and that's to think about false guilty plea rates. So, but first of all, the limited data that we do have with respect to voluntariness and autonomy, adults do appear to be more attuned to the difference between legal choice and practical choice. At least they can articulate that. Well, I knew I could go to trial, but let's be honest here, I really have no practical options. Adults seem to be a little bit more attuned to that, at least in our data. We talked about this already. Youth acknowledge choice, but they're often not clear on what they're choosing between. Does that implicate understanding? Does it implicate voluntariness? I don't know. It's kind of a gray kind of area for me, right? Because you may be voluntarily making a decision, but you're making that decision without having having improper information about what the options are, right? So in any event, I think the field generally is really raising the question of whether or not plea bargaining is inherently coercive. It's outside the scope of this talk for me to get into this in any kind of detail. But I think what I want to note here are just some of the reasons why, from a psychological perspective, it may be the case that many defendants don't really have the capacity to exercise choice in any real sense of that word. Massive sentence differentials can be leveled at defendants. Life versus a handful of years, right? The legal process itself is burdensome, particularly if you're an adult and you have a job and you're going to lose your job because you have to be at these court dates or because you're detained, right? So these things, again, are these contributing to a system that really leaves defendants with no choice? Certainly power imbalance between the state and the defendant. There's a lot of things we could talk about here, but the one that we've mentioned already is just the information deficit, right, that many defendants are at relative to the state. So in terms of like evidence in the case and so forth. And then of course, the system inequities that we mentioned. I think the clearest way to kind of ask ourselves if the system is coercive and if voluntariness is more apparent than real, is to look at false guilty plea rates. And so I just want to highlight here that plea bargaining has a known innocence problem. This is not something I'm revealing to you for the first time. About 1 in 4 documented US exonerations in the United States involve a defendant who pleaded guilty, a defendant who convicted himself. Self-report range from anywhere from 20 to 40% of defendants saying, yeah, I pleaded guilty, but I didn't do it. It was, these are the options that were set before me. And of course, self-report, there can be some problems with that data, but it tends to be pretty consistent. And most people do say that they are guilty of the crimes they committed, right? So most people who plead guilty are guilty, but a sizable percentage of individuals likely are not. And what we are beginning to learn, which is most relevant for our talk here, is that youth are at increased risk. And there are a number of reasons for this. If people want to ask questions, happy to discuss this further, but the data are continually mounting and pointing in the same direction, that youth are at elevated risk to plead guilty when innocent. Okay, I'm going to actually, this slide is really more about, limitations on the research, cautions from generalizing from the existing research. I think this is pretty self-explanatory. I don't want to make too many leaps from the data that we do have, and we need more research. But I just want to quickly sum this up and highlight just a couple of implications that we can maybe think about more in the Q&A, or that folks can think about more going forward after this talk. So to sum up, okay, some youth are at risk to plead guilty with insufficient knowledge. This is clear because we have data on actual kids who've gone through the system. Developmental immaturities and limited experiential knowledge can really reduce the capacity for these youth to generate and appreciate the full range of potential consequences. And youth may be more susceptible than adults to pleading guilty when innocent. Very quickly on implications for research, policy, and practice, there are a ton, but just I'm going to pull out a couple of things here. I really think from a practical standpoint, I'll skip over more of the research items. We really have to think about research practitioner partnerships. Plea bargaining happens sort of behind closed doors, black box. We need to bring it into the light to really be able to study it. We need to understand it better. We need to think about developing tools. We are well positioned as psychologists to develop tools that can facilitate attorney communication and evaluation of clients in the actual, we might like to say, well, they should have more time. They should have more time. Yes, of course. They should have more time. A lot of things should be different about the criminal justice system. But right now, what can we do? How can we leverage our skills and knowledge to develop tools that attorneys can use right now to facilitate communication and evaluation of their clients? Our lab is actually working right now on such a tool, and I'm really excited about it. I look forward to see where that's going. I don't like to make too many strong policy recommendations from limited research, but I think these things are things we can at least begin thinking about. We can recognize, at least the data that we have right now, at least in some places, the existing safeguards are insufficient, and we should be thinking about how to make these safeguards more developmentally responsive. Maybe we should be thinking about presumptive incompetency for youth below certain ages in the plea context. Maybe we should be thinking about revisions of plea colloquies for cases involving youth. And I'm sure some jurisdictions have and are doing these things, but again, wide variety across the states. And then finally, a few practice points. Attorney and judge training on developmental issues. We should think about increasing that. Again, we have a lot to offer there. For those of us who do forensic assessment work, really thinking through when you get a youth, it may be rare that you get a youth who's got a competency referral and is going to plead guilty, or the plan is for him to make a plea decision. You may, I don't want to say it's rare to get that, because obviously if you get a kid there's a competency question, of course he may have to make a decision on a guilty plea. But the point I'm making is a lot of the tools that we use right now and a lot of the things that we think about in terms of assessing adjudicative competency don't necessarily cover completely the context of the guilty plea process. And so as evaluators, we could begin thinking and adding some of those components to our assessments where they are currently lacking. All right, I've gone quite a bit over. I apologize for that, Anthony. I'm going to go ahead and stop sharing my slides and let you take over from here. I hope it wasn't too rushed at the end.
You're right on track. Thanks so much, Dr. Zottoli, Tina, for that discussion. We already have a lot of questions already here. I'll try to integrate some of those. For those of you that have questions, of course, feel free to enter some more in the chat there, and we'll get as many as we can for the next 10 minutes or so. One question here kind of winds all the way back to the core of some of your earlier discussion, and someone wanted to clarify. You brought up different discussions about trends in terms of cognitive abilities maturing at certain ages. And what do we mean by mature? Could you define mature in that context?
Sure. So I'll define it this way. This may or may not be the way that the individual is asking the question, but in the legal system, the standard, right, is the reasonable adult, right, who does not have any mental disease or defect, to use legal language. And so on the one hand, what we're talking about here is whether or not adolescents can perform, right, at the level of that reasonable man, right, the typical criminal defendant. And so that doesn't, that is not a particularly high bar, right? We're not, you don't need to be a rocket scientist. You don't need to have 160 IQ. So we're not looking at that, but just, do they have the capacity to make decisions, to understand their rights and so forth, as we would expect a typical adult without any serious mental status capacities to have. Now, the other side of it, of course, is what do we mean by mature from a scientific standpoint? And you know, the brain is changing all throughout life, right? So I don't know that I can give you an answer like, oh, at this point, when all of these changes have happened, the brain is mature. Certainly at some point, right, individuals are able to function. They're not having the same problems that they're having with respect to like being unable to exert control over their emotional responses and so forth. And generally, we see that behaviorally happening at this point by about the mid-20s, and we have neural correlates that seem to support that as sort of like the end point of this of maturation. So we have both the behavioral manifestations that we see normatively sort of reaching kind of like that maturation in 20s, and the neural changes sort of kind of correlate with that. That may or may not have been what the question asker was asking, but I think that's the best answer I've got.
Wonderful, thank you. Getting at the core of this from like a clinical perspective, somebody asked, what exactly is the role of psychologists in determining if a youth is intellectually, emotionally capable to agree to a plea?
So that's a great question. The fact is, well, let me say this, I can't speak for most practitioners, but I do guilty plea work, and I get very few cases where I'm being asked strictly about issues of voluntariness and the knowing and willing aspect. Usually, as practitioners, we're getting competency evaluations, right? So does the person have the capacity? So is there much of a difference, right? So the standard for adjudicative competency, whether you're pleading guilty or whether you're proceeding through a trial, is the same. And so the role of the mental health practitioner who gets a competency referral is to assess, right, the DUSCI standard for that individual. As I'm sure most people in the audience are aware, although there is a single standard, the way that we do evaluations is contextual. So we have to understand what are the kinds of decisions the person might be facing, how complex is the case, and we need to evaluate their capacities in light of those things. And so I would argue that really the existing tools and the ways in which, at least Anthony and I went to school, the way we were taught to evaluate competency, the tools have maybe a question or two on plea bargaining, but they certainly don't really flesh out the complexities of the process of waiving all of these important rights and understanding the implications of those rights. So I think as mental health practitioners, and I sort of alluded to this on my last slide, is I think we need to incorporate those kinds of questions into our competency evaluations when those questions come to us. Now, that said, I think as more and more of this research is coming to light, I think we will find that the role of the mental health or the forensic examiner may increase with respect to evaluations for youth in the system. But right now, I think it's rare that you're going to get a referral that's strictly about the plea itself.
Certainly, and this can, of course, can be, jurisdictional dependent. If your state is explicitly requiring any DUSCI-esque kind of standards attributed to a certain factor versus regardless of the factor, does this person understand this? And you could tie emotional maturity there too.
Absolutely, yeah.
Someone asked if there are any associations between youth understanding of plea decisions and trial processes with recidivism rates. And they elaborated, seems like an experience kind of question. In other words, do youth who have multiple subsequent charges have different or perhaps improved understanding of the plea process?
That's a really good question. We don't have data specifically answering that, but we do have data from the confessions arena, and I think it's quite relevant. No, just having, look, there are going to be certain things, right, that kids who have been in the system before are going to know and recognize, but at least from the confessions literature, my understanding of it, no, it doesn't really make them necessarily more capable of understanding or appreciating. Those really do, I think, a lot of it does have to do with developmental maturation, right? To really appreciate long-term impacts. So.
You spoke of differences between hot and cold decision-making. And this person asks, and the fact that youth on average have about an hour to reach their plea decision sometimes. Do you consider plea decisions a hot or cold decision, and why?
That's a really good question. So I actually, as I told Anthony earlier, I pulled a ton of slides out of this talk because I knew I didn't have the time. But the Supreme Court would consider plea bargaining to be a cold context. It's well, you've got an attorney and you've been charged and you have all this time to deliberate. But that is not really what we see in practice. I mean, look, certainly, are there cases that proceed, you're on your way to trial, the case is being investigated, and then at some point a plea agreement is made? Sure, but that's not the typical case. These typical cases happen quickly. I had intended, and I had forgotten to pull data. We have some data on like the time to plea from like initial charges to actual conviction. It's quite short in our data. And I know that it's generally quite short. Anecdotally, and from the data that I presented today, the decisions are being made really, really quickly. And so I would consider most plea decisions to be a hot context. Not all of them, obviously, but I think that many of them certainly are.
And I guess related to that, someone had a question on those realms of if that issue applies specifically to youth, or is that more reflective of broader for youth and adults in the legal system?
That is true for defendants generally. The plea system is, if Americans knew actually what it really looked like, there might be some changes to it. No, it's quite quick. Do I have time to give a very small anecdotal story, or are we
go for it?
Yeah, so just very briefly to kind of highlight this, I'm going to just describe, without identifying details, a wrongful conviction case that I worked on a few years back. The individual was arrested, charged with a crime, and was at the court in a holding cell waiting for an appearance to make a decision on that case. While in that holding cell, he was presented by his attorney with a whole new set of very serious charges, which indeed, as would be found out many years later by DNA, he was in fact innocent of, but was threatened with such a severe penalty and basically told, you've got to make this decision now because we can combine these cases, and I'll leave out a lot of the ensuing details, and effectively had 20 minutes to make that decision, and ended up pleading guilty to a crime that he was innocent of. And this was a grown man. So yeah, it is, unfortunately, it is more common than, I'm not suggesting every single case is like that, please. And I wouldn't have a way of knowing that anyway, right? I know what I know, I see what I see, but it's definitely far more common than most people would imagine.
Someone asks broadly here, given the speed, the relative absence of protective factors, coercion within the juvenile justice system, would you conclude that justice is often denied in this system?
As a scientist, I like to avoid answering those kinds of questions. I'm gonna give myself a little pass here and say I'm going to answer this as a citizen looking at the science, and I'm going to say that I think justice is often denied. I think the science does point in the direction, at least I can say this, the expectations that the law has about human behavior, or the assumptions that the law has about how these processes should work in the service of justice, they are not working that way. And so, yeah.
And one last question here, again, from a clinical perspective is, given all of this info, if a clinician were evaluating a youth for competency, what is something particular that they should know about youth development in order to properly assess whether or not they can make these kinds of legal decisions?
Well, here's actually an interesting, I should have mentioned this earlier and I didn't. If you're getting a referral for a kid, it's a competency referral and the kid may be making a decision about a plea, you've kind of pulled out of the equation a lot of that hot pressured stuff that we talked about, right? Because this kid somebody has figured out this kid's got some struggles. He's having a hard time making these decisions and he's gotten sent over to a mental health practitioner. So I think the first thing is you sort of remove, or at least that in that context, that kid isn't in that same kind of like pressured situation like some of the kids I was describing earlier. So it's a little bit different. Now, having said that, you obviously have to take for granted that a situation could still arise in that case where that kid is in a pressured context. And generally speaking, kids are going to have more difficulty there regardless. But I think when you are evaluating youth for the capacity to understand these things, I think it's important to ask questions that what does it mean to understand the function of a right, right? So I think it's really important for the clinician to assess whether the youth understands how that right is, what it gives him and how he can use it to like facilitate his own defense, or how it protects him, more than just understanding, I don't have to force the prosecutor to make the case against me. Well, what does it mean to force that prosecutor to make the case against you? Really getting at that, I think would be helpful questions to ask and to evaluate. So.
Dr. Zottoli, Tina, thank you so much for sharing both your general area of expertise and as well as just touching on a really vulnerable and critical issue that sometimes indirectly hits a lot of the clinicians and certainly touches a lot of the legal scholars here that are on this talk. Very much appreciated you sharing all this information with us.
Great. Thank you so much. It was great to be here.
Wonderful. And that wraps up this week's Law and Mental Health series. We hope to see you again next week and the weeks thereafter. And until then, have a fantastic rest of your week, and we'll see you again